Deputy District Attorney Anne-Marie Rosa here with a question I often get. When is homicide not murder, but manslaughter? In a previous lesson you learned that PC 187, murder, requires several elements, including malice aforethought. Malice aforethought means the killer, with wanton disregard for human life, does an act that involves a high degree of probability that it will result in death. On the other hand, California's voluntary manslaughter laws apply to killings that are committed during a sudden quarrel or in the heat of passion. In other words, there is no element of malice aforethought. Let's start with the jury instructions found in Cal Crim 572, voluntary manslaughter, murder not charged. They state in part that to prove that the defendant is guilty of voluntary manslaughter, the people must prove that the defendant committed an act that caused the death of another person, and when the defendant acted, they unlawfully intended to kill someone. The people must prove that 1. The defendant intentionally committed an act that caused the death of another person. 2. The natural consequences of the act were dangerous to human life. 3. At the time they acted, they knew the act was dangerous to human life. And 4. They deliberately acted with conscious disregard for human life. If self-defense or defense of another is claimed by the defendant, the instruction that they killed without lawful excuse or justification is read. The jury instructions go on to say that an act causes death if the death is the direct, natural, and probable consequence of the act, and the death would not have happened without the act. A natural and probable consequence is one that a reasonable person would know is likely to happen if nothing unusual intervenes. In deciding whether a consequence is natural and probable, consider all of the circumstances established by the evidence. There may be more than one cause of death. An act causes death only if it is a substantial factor in causing the death. A substantial factor is more than a trivial or remote factor. However, it does not need to be the only factor that causes the death. Provocation and imperfect self-defense are not additional elements of voluntary manslaughter. People v. Rios 2000. Voluntary manslaughter is also committed when one kills unlawfully and with conscious disregard for life. If causation of death is at issue, the court has a duty to instruct on proximate cause. If the evidence indicates that there was only one cause of death, the court should give the direct, natural, and probable language. If there is evidence of multiple causes of death, the court should also give the substantial factor instruction, People v. Autry, 1995. While the legislature has included the killing of a fetus within the definition of murder under Penal Code Section 187, the provisions of Section 192 defining manslaughter as the unlawful killing of a human being with no mention of fetus. So, for example, someone commits manslaughter when there is adequate provocation that would provoke a reasonable person to lose all self-control and act in the heat of passion. An example may be coming home to find someone having sex with your spouse and killing that person. As a prosecutor, I rarely file a voluntary manslaughter as a separate charge. This issue usually comes up in murder cases, where the accused admits to killing the victim, but seeks have the charge reduced from murder to manslaughter. This can be accomplished through a plea deal or convincing the judge to give the aforementioned jury instructions on manslaughter. The jury then has an option of finding the defendant guilty of the lesser offense. That is today's lesson on California Penal Code 192. A. Voluntary manslaughter. You will see questions on the exams and other assignments related to this lesson.